to do the introductions, or did you want me to do?
No. I will just going to introduce all the panel, including you, who will be the moderator of today's webinar. Then the floor is all yours.
Okay, great.
Shanti, live is started. You can start now.
Ladies and gentlemen, welcome to all of you to the second International Law Fest and one of the segment that is International Webinar on Justice Mechanism for Genocide. Welcoming you all, Ridwanul Hoque, Vice President, Advocacy NILS Bangladesh, and the organizing head of Second International Law Fest. Ladies and gentlemen, today we have our special discussion panel for this international webinar. I would like to introduce our first panelist, Irene Victoria, the human rights lawyer and head professor of human rights in Latin America, Department of International Education, National Universities of Terres de Febrero. Our second panelist is Dr. Ridwanul Hoque, sir, professor, Department of Law, University of Dhaka, University Fellow, Northern Institute, Charles Darwin University. And our third panelist of today's international webinar, Patrick Burgess, President, Asia Justice and Rights, AJAR, and welcoming you all. And today's international webinar going to be moderated by Nicole Janisiewicz, Legal Advisor, Asia Justice and Rights, AJAR, former attorney in the Office of the Prosecutor, ICTY. Welcoming you all, everyone. Now, Nicole, the floor is yours.
Great. Thank you very much, Shanti. And thank you for inviting me to participate in this panel. I'm looking forward to the discussion. We're going to go slightly out of order, just to be sure to accommodate the demands of all of our speakers. So without ado, I'd like to jump right into having our speakers provide their comments. We'll begin with Professor Ridwanul Hoque. He is a professor of law at the University of Dhaka and a university fellow at Charles Darwin University's Northern Institute. He obtained LLMs from the University of Chittagong and the University of Cambridge, and his PhD from the University of London. He was an Endeavour Fellow in the Center of Comparative Constitutional Studies at Melbourne Law School and a Fulbright Fellow at Cornell Law School. He has also held visiting research and teaching positions at La Trobe University Law School and National Law University, Delhi. Professor Hoque is a leading scholar of South Asian constitutional law, specializing in comparative constitutional law and theory, and has a special interest in inclusive constitutionalism, including indigenous constitutional inclusion. Professor Hoque has written a much acclaimed book, Judicial Activism in Bangladesh, A Golden Mean Approach, and over 30 articles in prestigious law journals and edited volumes. He has provided several expert reports for UK, US, and Australian courts on different Bangladeshi law questions, probably most prominently the law of citizenship. Professor Hoque has been widely consulted by government ministries and international organizations on a variety of issues relating to human trafficking, child rights, women's rights, and international labor migration. And he concluded a major project on the protection of Rohingya refugees from human trafficking, and I believe is also going to be discussing more of his Rohingya work with us today. Professor Hoque, the floor is yours.
Normal girl. She's supposed to.
Thank you very much, Nicole, for your kind and very, very gracious introduction. I do not deserve all these things. As I said, I am a little unwell, but I mean, since the event is so important or is focusing on such an important, significant issue that touches our life and also the lives of a wider number of human beings, the Rohingya people. So I'll be sharing with you my very, very negligible little experience of being involved with an amicus note, amicus brief that the non-governmental representatives from Bangladesh submitted to the International Criminal Court with regard to the Myanmar jurisdiction case. And I would be very, very brief. Actually, I'll be speaking only for 11 to 12 minutes. And the very learned panel, and Nicole is an insider, and as is Patrick and other people. So you'll be able to hear more and more from them. So we all know that, I mean, the prosecutor or the prosecution of the International Criminal Court requested the court for a ruling on jurisdiction over Myanmar. The difficulty of this petition was the fact that Myanmar didn't subscribe to the ICC statute. On the other hand, is neighboring country in which the victims took shelter, took refuge, was a party to the International Criminal Code. It has been a novel and first of its type case. Of course, there were some scholarly arguments, some judicial observations regarding international courts' jurisdiction over a non-party or non-member state. Anyway, the thing is that, I mean, when the prosecution's application for a ruling was being heard, in the meantime, a Bangladeshi representative, non-governmental representative, submitted an application for leave to submit its observations or amicus brief, and that was submitted on 13th June 2018. And within 5 days, the pretrial chamber 1 granted the representatives the leave. So we are ready to submit the, sorry, it's not 18 June, it was, the leave was granted on something like 14 June. Well, 14 June, a day after we submitted the application for leave to submit amicus brief. Then from 14 to 17, we got extremely brief time to submit this amicus brief. So we submitted the brief on behalf of the Bangladeshi non-governmental representatives on 18th of June 2018. And there was another important amicus brief from Bangladesh, and that was by non-governmental organizations or civil society members, independent of this one. And there were other amicus briefs. One was by International Commission of Jurists, and another was by the Canadian Partnership for International Justice. In the court's grant, the scope of our brief was limited. So we are focusing on 3 different issues. The number one is circumstances surrounding the Rohingya situation. I mean, the facts of the applied, their genocide, torture, murder, rape, sexual violence, everything, circumstances, factual kind of things. The second one is the crimes, apart from the deportation, the crime of deportation. So it's very interesting. The deportation was focused on or dealt with by other amici, but our duty was to focus on other crimes than deportation that originated in Myanmar and were completed in or were continuing in Bangladesh. So, and the third issue was Bangladesh law relating to Bangladesh's extraterritorial jurisdiction over cross-border crimes. And that is actually not an international law issue, domestic law issue. So these are 3 important issues that our amicus brief focused on. And I'll be talking only on the second issue, that is the crimes in addition to deportation. So what we did, we went through the facts, and we had gone through the laws and other things, everything. then we were able to concretize that indeed there were many other crimes than deportation. So, for example, crimes of murder, for example, torture, sexual and gender-based violence, acts of persecution, and finally, genocide. So we differentiated between deportation and genocide. It's very clear, the facts is obvious. So in case of all these individual heads of crimes, so our main argument is that every single crime originated in Myanmar but was completed in Bangladesh or was still ongoing a crime. For example, murder. So the element in murder is the death of the person. But we showed that in some cases, the deaths occurred within the territory of Bangladesh, in Bangladeshi hospitals, in Bangladesh land. But the offense started in Myanmar, say for example, the injury. And with regard to the sexual and gender-based violence, rape, for example, we showed that the enforced pregnancy initiated or was initiated in Myanmar, but was completed or was continuing in Bangladesh. So we showed the facts of pregnancy and the births of children out of those rapes. And the same thing happened with reference to genocide. So that's very obvious. So, so these are the things we focused, and we just for the benefit of the participants. So, in addition, since we are to deal with the crimes apart from deportation or criminal deportation, and we basically relied on few articles of the statutes, ICC statutes, and predominantly Article 7, 1A, B, and Article 12(2)(b). You may take a note and you may later have a look on this. And most importantly, which is very related to today's main theme, is about justice for genocide. So the final count of crime was genocide, and that was under Article 6. And we all know that the result, how brilliant the result was, how impactful the result was. And it was so impactful that, I mean, now side by side with ICC proceedings, there is another proceeding in the International Court of Justice, and that's the first ever proceeding under international crimes or deportation, and particularly against a state which is not a party to the ICC, although it's the jurisdiction of the International Criminal Court, sorry, International Court of Justice. Now, I can't resist just sharing the process of this amicus brief. So it was very interesting exercise. We were 26 members of this group, non-governmental representatives, and my name appears on number 25. And so with the brief, the list of the people went as Annex A, and the people who actually drafted this amicus brief went in the list B as Annex B. So I led a small Bangladeshi team in just 3 days, and most of the members of the team were also the members of this group, non-governmental representatives. However, we had another partner organization, law firm based in London, that's Lyons Chambers. So they did their part, and we did our part. So, and we had to collaborate between Dhaka. I was based in Australia at the time, so we collaborated around the clock between Dhaka, Australia, and London. So, and one important and very interesting factor, so it's for the benefit of the students, participants. That is, so if you look at the court documents, you'll see that the amici were named as only 2 people in our brief. Is Manzoor Hassan, who is at Bragg University, and Parveen Hassan, Vice Chancellor of a university in Dhaka. So those 2 people were named, and we actually, with the 26 people, authorized them to represent us. So in the first page of the brief, it were just these 2 people. So all interesting, I mean, facts and factors are involved, and a lot of negotiation, communication, or communications are also involved. And finally, we were able to submit this wonderful draft, wonderful brief to the ICC in just 3 days. So with that, I would like to stop, but I would like to stop by thanking the organizers, especially Nasreen, who contacted me, and I mean, very kind of her. So she remembered me on this occasion, which is a great event for the cause of justice. Because lastly, but not the least, we the Bangladeshis are the worst victim of genocide in the world history. That happened in 1971 from March to December. So this is the month when we can also remember our
Sir,
past.
this
And
month
thank you
is
very
very
much.
significant in this regard also.
Yes, it is. So thank you very much, Nicole, and all other.
Thank you so much.
For kind patient hearing. Thank you.
Thank you, Professor Hoque, for joining us. And I understand you do have to leave, so you know, when you have to go, feel free to depart us. We really appreciate you taking the time, though, to provide your comments. Really interesting to hear kind of the insider's perspective on that process. So thank you for those comments. We'll move on now to our next presenter, Professor Irene. Oh, I knew I was going to kill it. Irene Victoria Massimino, who is a human rights lawyer, professor, and activist. She's a graduate of the National University of La Plata in Argentina and holds an LLM from Indiana University and a Master's of Human Rights from the University of London. She also has completed all compulsory intensive courses for a doctorate from the University of Buenos Aires Faculty of Law. She is head professor of human rights in Latin America at the National University of 3 de Febrero and a head professor of jurisprudence in the Latin American system at the National University of Jose Sipas, also in Argentina. Professor Massimino has served as rapporteur of the Criminal Cassation Court of the Province of Buenos Aires and works actively in the fields of internal and international conflicts, serious violations of human rights, and international criminal law in relation to the experiences of Colombia, Argentina, Chile, Guatemala, Bangladesh, and Iraq, focusing mainly on external intervention and the crime of genocide. She is a member of the American Association of Jurists, the Global Alliance for Justice Education, and the Argentine NGO Asociación Pensamiento Penal, realizing I really need to brush up on my language skills. In addition, she is a former co-secretary treasurer and a current member of the Resolutions Committee of the International Association of Genocide Scholars. Professor Massimino, thank you for joining us, and you have 20 minutes.
Thank you, Nicole. Thank you, everyone. It's my pleasure to be here. Thank you, Patrick, for sharing the panel, and Professor Hoque as well. Nice to meet you, Patrick. I don't think we've met in person. Hopefully one day we will. I apologize that if I'm not very coherent. It's almost 3 in the morning in Argentina, so it's not very easy to be awake, and I apologize for this same reason. I haven't been in the opening of the conference, but hopefully I'll be in the closing tomorrow since it's a holiday for me. So anyway, I was asked to speak about the different processes of justice, legal options that we have for justice processes. I talk about legal options because, well, we do have other options to deal with genocide and other crimes. However, I want to focus in this particular aspect. I will talk about national and international justice system. I will try to stick to the 20 minutes to pursue accountability for genocide and other international crimes. And I will address some historical experiences of Latin America, for example. That's what my experience is most about, and examine the impact of each of these justice processes to discover truth, historical building of the memory, recognizing victims, and creating accountability for perpetrators. Many of these processes certainly have many challenges, and I have time after the presentation for questions, and we can discuss a little bit more. I don't want to make it too long. So I divided my presentation into what are national justice systems and international possibilities, right? Amongst national tribunals, we have examples, many examples in Latin America, for example, and also in Bangladesh. Many of you, I'm sure you're more than aware of this, and probably more than me, of course. A national tribunal and the different possibilities that we have will depend a lot on the political organization of the country. For example, in the case of Argentina, Chile, and Guatemala, federal tribunals and different courts around the country using the criminal code, the national criminal code, and the ordinary criminal code of procedure, hold trials for genocide and crimes against humanity or war crimes. The cases of Argentina, Chile, and Guatemala in particular are ongoing at the moment. They have started in different times, and they have had different aspects of the process amongst more than 30, 40 years of existence. However, they're ongoing at the moment, and they usually happen in national, federal, ordinary tribunals, not tribunals specifically created for the crimes. That's the other case of national tribunals that I would like to address briefly, is those created with the specific purpose of the crimes committed. So it's usually a special branch in the ordinary judiciary, like the case of Colombia, for example. Colombia has changed a little after the peace agreement signed relatively recently, I mean, in contemporary history, of course, speaking about that. So it has a specific, it continues to deal with the cases of genocide and crimes against humanity within the ordinary judiciary, and now has a specific forum for peace or a specific branch created for peace. Or the case of Bangladesh, for example, where national tribunals or a specific court was created, in this case, the ICTY, and after the 1973 Act. So the International Crimes Tribunal uses specific law and specific procedure, as different of what I was highlighting before about national tribunals. So what I'm trying to present here is the different options that we have when it comes to crimes against humanity, genocide, and other international crimes. It doesn't have to be always an international option. However, we have to look at each particular circumstance to determine whether or not we can use these mechanisms. Of course, we can, I guess after the discussion, I mean, during the discussion after the presentations, we can talk about specifically the Rohingya case, for example, or whatever you're interested about, or specific cases. However, using national tribunals has been sort of very, not popular, I wouldn't like to use that word, but I can't find a synonym in English. It has been very common in the recent years, mainly in the 20th century, in the Latin American region, due, of course, to a political wave pushing for these national tribunals and pushing for this justice, memories, and truth ideas and search. So another way of using a national system is that I like to address briefly is through universal jurisdiction. You might have heard of this, and it has been used recently a lot in the cases, for example, of Iraq and Syrian conflict, in the cases of ISIS, members of ISIS, perpetrators that are members of ISIS, and jurisdiction has been opened nationally in through universal jurisdiction in Germany, for example. But it's not fully new. Actually, it has been around. It's in the 1949 Geneva Conventions for the violations of humanitarian law, articles 49, 50, 129, and I can't remember anymore, but the Protocol 1 as well, and the 1954 Hague Convention. Many countries accept universal jurisdiction nationally. That is the case of Argentina, for example. Our constitution, since its creation in 1853, includes universal jurisdiction. It's a long history. It was first used in an international court in 1929 in the case of the Lotus, the coalition of two vessels, a Turkish vessel and a French vessel, and that gave the idea that there was a criminal jurisdiction that could be open that was not related territorially or to the victim, but for different reasons. In the case of universal jurisdiction, of course, the idea is that the crimes are so heinous and so atrocious that go against global morality, and therefore any country that allows universal jurisdiction should open. It's not only a right, but also seen as a duty, and should open jurisdiction in order to try perpetrators. For example, in 2006, it was included in the International Convention for the Protection of All Persons from Enforced Disappearances. It was clearly included. So again, it does depend a lot on the political scenario. I guess when we talk about human rights and international crimes, it's always, the political aspect is always there. And if we find a historical moment that accompanies a process of justice, then it will be definitely a lot easier to either open a national tribunal, open universal jurisdiction, a national tribunal through universal jurisdiction, or even international justice system. So, for example, in customary law, I like to bring out some examples. Spain's national jurisdictions opened many times for the crimes committed in Argentina, Chile, Guatemala, and also El Salvador. It opened generally around the 90s, because in the 1990s, because that was the time when our countries would have impunity or had impunity for the crimes committed during the 70s and 80s. And therefore, many human rights organizations, and many of them representing the victims, but others just because they were human rights organizations, presented cases in Spanish courts. And of course, they opened up those cases. One of the famous ones that maybe some of you will know, or all of you will know, is the case against Pinochet, the former dictator of Chile, who ruled from 1973 to 1989, 1990, 1991, when was the peace agreement and the final recovery of democracy. So anyway, a case opened against him in Spain, and therefore he was requested extradition when he visited England, but unfortunately he wasn't given extradition on the grounds of his health. However, we think that it was because of the historical connection Pinochet had through the years with, for example, Margaret Thatcher, the United States, etc. So these are other examples where universal jurisdiction opened. Like I mentioned, national courts have opened it. Argentina opened it many times. It has opened universal jurisdiction for the crimes committed during the dictatorship, Franco's dictatorship in Spain. We have opened universal jurisdiction for the case of Rohingya. I'm sure you know of it, and it's the process. Unfortunately, like I mentioned in many of the conferences that we have these days, this pandemic has not only affected in many other aspects like our health and our current life, but it has strongly and unfortunately in a very a negative manner has affected justice processes worldwide for victims of genocide, victims of crimes against humanity, etc., refugees, etc. And I think at least on this side of the world hasn't been addressed as much as I would have liked to hear about these cases. But anyway, we have opened it as well for the case of, for example, the attack in the Gaza Strip in 2014. Anyway, Germany has opened it, Belgium has opened it, I think, for ISIS perpetrators as well. And anyhow, like I said, it depends a lot of the internal legislation accepting this jurisdiction, of course, and if not included specifically in the internal jurisdiction, then it depends on the interpretation of the judiciary on how to open it. And then we have the other, leaving aside national courts, we have international courts, like Professor Hoque mentioned, the ICC in particular, and his experience with the ICC. The ICJ, of course, many of you have heard of it because of the case of the Rohingya as well. Special ad hoc courts that we've heard a lot in the recent years, and then hybrid courts, for example, like the one in Cambodia, closer of course to you. I don't want to go specifically into them. Everybody knows the process in general, and it's what usually is requested when a case of genocide, crimes against humanity, or other international crimes are open. Yet I wanted to mention it to not leave them aside. I always like to focus a little bit on what is not that common, because sometimes in what is not fully common, we can find a piece or a hole where we can bring our case or build up a case through the years. Unfortunately, justice never comes immediately, and at least in the cases that I've experienced, that I have work experience and I work with, it comes maybe 30, 40 years after the crimes have been committed, even more than that, or it never comes, unfortunately. I think now we're more aware of the necessity of this, and I say never comes because I'm thinking of the 1915 genocide against the Armenians, for example, that have never had a proper justice process. But I do think society is more aware of not only of the necessity, but of the tools that we have. And that's why I think it's so important that we have these conferences and then we exchange on the possibilities of different, either legal and judiciary forms of national or international forms of justice. And I would like to briefly address as well truth commissions. I don't know if I have enough time, Nicole. I do have time. Okay,
yeah,
I want to.
9 minutes or so.
Okay, perfect. I want to address briefly what truth commissions are. They're legal, but not judiciary. They're established, of course, in the legal system of a country. They're usually approved by whatever means of organization a country has, the parliament, the Congress, etc. And we've had, as well in Latin America, quite a few experiences of truth commissions, and they have worked greatly in gathering information and gathering evidence for future trials, and with that I mean judiciary forms of justice, right? And for example, in the case of Argentina, the National Commission on Disappeared Persons was created right after the end of the dictatorship in 1953, and it came up with the famous Never Again report, as you know, the line never again. And the evidence gathered there was used further in the 1985 trial to the juntas, to the all military perpetrators, the head of the military juntas, and then it's been used and it continues to be used in the current trials that opened up in the 21st century around 2005, 2006. The same occurred with Chile right after the ending of the dictatorship, which was a process of a peace process, which included a peace process, sort of like the Colombian. Unfortunately, the Colombian peace process is failing in the recent months. And they came up with a rating report. The rating report also was followed by the National Commission on Political Imprisonment and Torture, which is known as the Valech Commission. The Valech Commission came with a even bigger reports than the original rating report, which of course, again, included many human rights, evidence of many human rights violations and other crimes, and is being used in the current trials in Chile. Chile is, again, as Argentina, has an ongoing process of justice in their national courts. In Guatemala, it's also very popular. The Historical Clarification Commission, again, a legal non-judiciary body, and it came up with a report, Memory of Silence of Guatemala, which after the peace process and the Oslo Agreement, again, the Guatemala was an internal conflict as well, considered a war, not only genocide or crimes against humanity, but also war crimes were committed. And therefore, the Historical Clarification Commission came up with a big number of human rights violations, then was later on followed by the Human Rights Office of the Archbishop of Guatemala, who came up with a report of the recovery of historical memory. It's Guatemala Never Again, and again came up with a huge number of human rights violations, bigger than the previous reports. So truth commissions, at least in the experience of Latin America, have been proven to be very efficient, mainly in addressing the victims' issues immediately before a proper justice process within the judiciary can be held. And it has also addressed properly the gathering of evidence. Not, of course, with many failures, but at least these bodies were created immediately after the different dictatorial or conflict nations finish their process of war or of conflict. And then we have the truth-finding trials. The truth-finding trials is a very particular and specific form of trial that I know occurred in Argentina, and they were held in 1998. Like I mentioned in the beginning, Latin America had a period of impunity during the 90s. By impunity, I mean that a lot of the perpetrators, which belonged to the military forces, the aviation, the Navy, and the army, were given amnesty. And many who were sentenced to life imprisonment were given amnesty and then set free. Therefore, Argentina, in that process, was not fulfilling the obligations given by the Inter-American system of human rights. And therefore, NGOs went to the Inter-American human rights system, to the Inter-American Commission in particular, and requested to intervene in order to have some form of justice. The Inter-American Commission ordered Argentina, they came out with the right to truth. The right to truth is very, very young in the world when we talk about human rights. And it means that individuals that are victims or family relatives of the victims of different human rights violations are entitled, and the state is obliged to let them know what occurred to them. But also has a collective component to it. Not only it's an individual right, but it's also a collective right of the entire society. So Argentina is obliged by this ruling of the Inter-American Court to find the truth in each human rights violations that occurred and that continue to occur, of course. Therefore, the judiciary in Argentina established the truth-finding trials. Because of the political scenario and different laws that would not allow to have an ordinary judicial process, Argentina had a very specific process. This was like an ordinary trial, but perpetrators could not be punished. Some perpetrators actually sat in the trials, and a lot of evidence was gathered. Many victims were able to give their testimony, but perpetrators were not punished. So this was, of course, there's a lot of conflict, and there is a lot of, I guess, philosophical judicial conflict in this, whether punishment is one of the main elements of a justice of a trial, an ordinary judicial trial, right? Or there are other components to it, and that's something that we can talk about later and bring up in discussion. But it's a very interesting element, because in this or not element, but it's a very interesting form of trial, because in these trials many evidence was gathered that was later used in the ongoing trials that we have today. So as you can see, not only in Argentina but in many countries of Latin America, the process of justice is a very complex one, and it had always behind a political decision. It was not just because the judiciary works or not. It was a political decision that either pushed the trials to find justice, truth, memory, etc., or it was a political decision to stop the trials, like it happened in the 90s. This is a pattern that we can see all over Latin America, and I'm sure we can see in other countries as well. Of course, not with national systems, but with either hybrid tribunals or international courts, etc. There is always a political scenario, either nationally or globally, that will push for the different forms of justice. So I hope I was clear enough. I don't know if I was. It's very dense issue and very complex, but I guess, I'm open for questions later. And I thank you all for this wonderful invitation and the possibility to participate in this conference. Thank you. Thank you, Nicole.
Thank you, Professor Massimino. You covered a lot of ground in a very short amount of time. I'm quite impressed, and really a lot of very interesting cases and particular examples. I'm looking forward to the discussion to come. But right now we'll switch to Patrick Burgess, who is a senior international expert on transitional justice issues. He is an Australian barrister and formerly acting principal member head of the Australian Refugee Tribunal. Patrick was the team leader of major humanitarian programs following the genocide in Rwanda in 1994 and in Yemen, Uganda, Indonesia, and Timor-Leste. He was appointed Director of Human Rights for 2 UN peacekeeping missions in Timor-Leste, which included responsibility for investigating war crimes. In this role, he was also the UN representative and chair of the steering committee tasked with establishing Timor-Leste's Truth and Reconciliation Commission, the CAVR. He helped draft the law that established the CAVR and worked for the commission full-time for 3 years as principal legal counsel. Patrick spent 5 years as Asia director for the International Center for Transitional Justice, and 10 years ago, he co-founded Asia Justice and Rights, AJAR. He has managed transitional justice programs and trained and advised government and civil society counterparts in, get ready, Afghanistan, Bangladesh, Indonesia, Thailand, the Solomon Islands, Myanmar, Timor-Leste, Nepal, Cambodia, the former Yugoslavia, Rwanda, Ethiopia, and Sudan. Patrick also co-created and wrote highly successful television series with rule of law and human rights themes in Myanmar and Timor-Leste, viewed by approximately 9 million people to date. He is also a professional singer-songwriter with original recordings available on Spotify and iTunes, so you can look that up as well. Thank you very much, Patrick, for joining us, and you have the floor. You're on mute. Yep.
Can you hear me okay?
Now we can.
Fine. That's the problem with having a little bit of age on your side. The CV keeps getting longer. Thank you very much for your introduction, and great to meet all of the students and all of the experts today. I've been asked to talk a little bit about the challenges in relation to justice and genocide. And I'm always interested more in what we retain after a presentation than what comes out. So I just want to, when we start to focus on this, I want to ask all of you to think about what you've retained from what I have to say, what you remember at the end. And the first thing I want to raise and ask you is, what are the challenges in relation to the 1971 genocide in Bangladesh and bringing those perpetrators to justice? If we were to ask you right now, what were the challenges? Why has it taken so long? What were the factors that took so long to find any kind of justice? Why has there not been a truth commission? Why have the victims received reparations? So you are the experts. I always say this, you are the experts in your context. I've worked in a lot of places, but you are the experts in Bangladesh. So what are the factors that you would raise? And I want to go through a few of those issues myself. And first of all, for you, how do you think that the genocide in Bangladesh is placed in Asia, for example, in relation to the experiences of Asia, your surrounding countries? Do you think that many other countries have had similar experiences? Let's have a quick look at, Nicole, can you enable the screen sharing for me? No? Okay, I want to move, come and go from my desktop if I can.
Yeah, I think you should now have that capability. Yes, there we go.
So if we have a look at some of the countries in Asia, This is just, and I don't want to dwell too much on this, but you see Bangladesh, 3 million, Cambodia, China, 20 to 30 million victims in the 20th century. Indonesia, many incidents. Timor-Leste, where I live and work for 6 years, had only a population of 650,000, 200,000 death toll up to is a massive influence on that country. So all of these issues, all of these countries have to face this issue in relation to the genocide and the crimes against humanity. And the big question is, and this is a question, this is a photograph I took in Tuol Sleng in Cambodia, where they photographed the victims that they very carefully interrogated and killed and recorded. What are the big challenges for us? And how do we stop the genocide from recurring? Now, when we do look through and find out what has happened in the different contexts where the genocide has taken place, we find some root causes to those problems, and there's a lot of them. These are just some of those that have come out of the work that I've done and the work of truth commissions: lack of respect for minorities, demonization of the minorities, and hate speech. In every context I've worked in, impunity has been a major contributor, perhaps the major contributor. And I always wonder, what would have happened in that context if, when the first killings or rapes took place, those individual soldiers were arrested and put on trial? Would the next soldier have raped or killed? And the answer is probably not. One of the factors that enables mass crimes is the lack of action and a failure of accountability. And you might think, in Bangladesh, what is the major challenge for impunity and justice? And certainly for justice, impunity and a failure of accountability is one of those factors. And there are bigger issues: failure of the rule of law, corruption, nepotism. It's interesting recently in the US experience to see the attacks of a very a corrupting regime, attacks on the judiciary, attacks on the media, attacks on the independence of the judiciary, the types of things that we see when there are dictatorships growing and dictatorships that lead to genocide. So what are we going to do about these challenges, and what are some of the challenges? I often work in the field of transitional justice, not always, but I do find, even after more than 20 years, that I make use of the transitional justice framework when I'm identifying the issues and developing strategies. And even recently, it was great to hear Irene talk about the problems of the COVID pandemic, because I've been speaking also about those issues in Asia, and looking at it, the failure to bring out the truth of how people are spending the money, of the actions of dictators who have prevented hospitals and medical staff from being trained of medicines, of looking at the victims. We can use this framework in a much broader sense. So I'm going to just have a quick look today. My time is very short. And my topic is the challenges of achieving justice for genocide. Let's have a think about Bangladesh and the challenges in uncovering the truth of what happened in 1971. What kind of challenges did you have? Some of them are common to other places. Often there's not much information about what happened. And my view is that very often we hear people say, oh, we know what happened. I've heard that many times. Patrick, we know what happened. We don't need a truth commission. My experience is that actually after mass crimes have taken place across a country, nobody knows what happened. People know what happened in their area or for a few years in a particular time. Other people know something else, but nobody knows what happened across the whole territory. And that's why, where they have been successful, and they are not easy to establish and implement, a Truth and Reconciliation Commission looks at the entire period of the violations. It looks at the root causes, the contributing factors, what happened, their effects, and the victims, and what should be done. So that process can gather the information across the entire context. And that's very different from most political or most trials as well, which are focused on particular individual perpetrators. Also, of course, in mass crimes, they look at the context, but it's very different from taking evidence or statements from, for example, in South Africa, 20,000 victims. In Timor-Leste, we took 8,000 victim statements. So that's a way of gathering information about, and that's a major challenge to achieving justice. There's not enough information. Why would there be political will to know the truth? If there's a transformation or a transition of regime, they may want to know the truth. But if the same actors who have contributed to or conducted themselves as perpetrators in those crimes are still there, they're not going to want the truth. They are not going to want to uncover the truth. There'll be no political will. They will deny it. And there will be different narratives. Each group, political group, armed group, has their own narrative serving themselves. And sometimes it's just a perspective they have, but they're conflicting. And the experiences of victims are also different. Some are the victims of one group, some are the victims of another. Other challenges, we have so many victims, hundreds of thousands. How can we gather the information? They're often weak, they've been victimized, they're uneducated, they're unable to push for the truth and their right to truth. There are no systems to collect that sort of mass information. Also, when there are investigations, and we've seen that with the Rohingya situation, NGOs and media outlets, newspapers, radio, television, flooded the camps, all taking statements from the victims and often the same victims. Some victims of rape reportedly have given more than 30 different interviews to different organizations. Those organizations are seeking to do something good, but without guidance, they're actually doing the opposite, using different methods, different standards, unreliable. In Timor-Leste, we had the same problem. And I remember seeing large black plastic bags in my office filled with statements of victims taken by NGOs from all over the world that we were actually unable to do anything with. They'd been taken on different forms, in different formats, with no consistency, by well-intentioned people, but re-traumatizing the victims every time their statements had been taken. So this is another challenge to justice in a broader sense. And I like to think of justice in a broader sense. This is justice for the victims and the way the victims have been treated. And in the terms of the word reparations, the real meaning of that word, repairing the lives of the victims. Another challenge is in relation to the information and the truth relating to sexual violations. A major challenge to be able to sensitively speak to the victims and bring out those stories. Because unless we, first of all, address the truth, we're very unlikely to be able to get any impetus for prosecutions. Irene referred to that aspect of the prosecutions taking a long time. The prosecutions don't just suddenly sprout up out of nowhere. The political will, the society's knowledge is gradually built up by truth-seeking processes, truth-sharing processes, to a state where the society supports prosecution. So we need, in my view, this push immediately after a transition to gather the truth. It's not enough to seek the truth. I always refer to truth seeking and sharing. The truth has no power by itself. It must be shared to have that power. We need to do this in order to create the foundation where it's possible to get justice in a criminal justice sense for genocide. Some of the other challenges, blaming of the victims by communities and families. And this is a terrible situation which happens and happens in many contexts that I've dealt with, where particularly, I mean, if you look at rape victims, women being shunned by their families, by the community, pushed out of the community because of actions which they had no say in, they were innocent victims. And I have a friend in Timor-Leste, for example, who was a sexual slave, passed from one to another and had children to 5 different Indonesian military officers during the occupation. She had been ostracized from her community, blamed for the fact that she was forcibly taken and raped by an Indonesian military personnel. And when they left, that person left on their tour of duty, she was passed to another officer. At this level of injustice for that individual is almost unable to be comprehended, and yet she was blamed by her community and rejected. So these are other challenges that we have. Now, what do we do about those challenges in terms of truth-seeking? That's another question. We have a number of methodologies that we can go through, and our time is short today, but I'll just refer to, I like to remember them in terms of official and unofficial means. The official means include Truth and Reconciliation Commissions, Commissions of Inquiry, fact-finding teams, National Human Rights Commission inquiries. So they're the official ways we can establish the truth and overcome these challenges. And the unofficial ways we can seek the truth, including the sorts of work that perhaps many of you have been involved in, documenting violations on behalf of NGOs, media reports, historians writing records, academics, the arts, theatre, creative, truth-seeking methods. So we use the official methodologies if we can, bringing the weight of the government and the authority of the government into seeking the truth, but we also need the unofficial means. So that's some of the challenges in relation to that part of bringing justice for genocide victims, and that is the lack of the truth. Now, let's have a think about the prosecutions. And once again, think about Bangladesh and the ICTY and think, what is it that has prevented that from happening for so long? What kind of things? And these things that are, some of them I've listed here, are very common. Very often the perpetrators are still in power. There's no will to prosecute, even when the perpetrators are not themselves in power. There is a kind of unseen and unspoken agreement that they shouldn't allow for their peers, their cronies, the other members of the elites to be prosecuted. This is sometimes dressed in the terminology of Asian values in Asia, which when you unpack it very often means that justice should be meted out for ordinary people for stealing motorbikes and stealing food, but not for the elites, even if they commit mass murder. That's often the meaning of Asian values in my understanding. Lack of independence of the courts, low capacity of the justice actors. Even if you were to draft a law for genocide in many of the developing world contexts, many of the Asian contexts that we looked at earlier, in terms of large numbers of victims, the courts, the understanding of the laws of genocide, of the modes of responsibility, of the context that needs to be established, as well as the individual acts, they're very complex, even for lawyers operating in the ICC and the international tribunals, let alone lawyers and judges who've had much less training, who work in a language other than English, who don't have access to all of that training and judicial sharing. So very difficult for national courts in many of those countries to successfully prosecute. In many of those cases, there aren't national laws on the mass crimes, including genocide. And in particular, you will find that there's nothing really like command responsibility or superior responsibility in the National Criminal Code. So being able to target the senior leaders for what took place at the grassroots level can be very difficult. There's low understanding of those laws and also how to investigate. And we often see discussions take place about having mixed or hybrid tribunals with judges from overseas and local judges sitting together, such as took place in Timor-Leste, Sierra Leone, currently still in Cambodia. But it's not only the judges who are responsible and who are required for successful prosecutions. And if the investigators and the prosecutors do not also have that type of support that can be given by internationals, often the job of gathering the evidence, of organizing it into successful, strong prosecution files, and of presenting that evidence is overwhelming. And I know in Bangladesh also some of those issues were faced in the early days of the tribunal, and also some of the issues around fair trial have been raised in Bangladesh by international organizations, lawyers, judges, prosecutors without experience in international crimes, and also perhaps susceptible to pressures, personal and societal pressures. So these are some of the issues that we're looking at in terms of the challenges. And just to go back, looking at the challenges of genocide, I'm using a transitional justice framework. We see the challenges in relation to gathering the truth. So many victims, very hard to gather the truth. We don't have the mechanisms. We can overcome that by establishing official and unofficial means of gathering the evidence carefully. In relation to prosecution, I think the major challenge is a lack of political will, the power that those involved with have, which we see in many countries still preventing active prosecution of those responsible. So then the third element to look at in terms of challenges comes when we consider the third foundation of the transitional justice framework, and that's repairing the lives of victims. What kind of challenges do we have in relation to repairing the lives of victims? And I always remember the word reparations. It's close to repair. It's repairing the lives of the victims. That is the goal of reparations. Now, an interesting factor is that I travel all over the world working on transitional justice, working with societies to find solutions. Reparations is always part of those discussions, always part of the plans, and very rarely comes to fruition in a meaningful way in any of the contexts. In some countries in Latin America, for example, in Chile and some other contexts, there have been relative successes in that regard, but in most of the countries of Asia, the success has been very, very limited. And especially when, for example, we see after the conflict, we see that there is advocacy and acceptance of the need to help victims and to provide funding and programs of reparations, alongside, for example, the DDR, demobilization and disarmament of militia groups and other armed combatants. One by one, if you look at all those contexts, you will see that funds and programs were established for DDR and in most cases were not established for the reparations program. So for me, I'm working on those contexts on that issue in a number of contexts right now, and I'm trying to advocate for a equal and parallel process of reparations and DDR. If the assistance is going to be given to former combatants, it should also be provided to victims. 1 minute. Okay, I'll just have a look quickly at that issue around reparations. Some of the problems: lack of understanding, lack of funding, who is a victim, the challenges of producing a list of victims is a very large one. And just, I know I have to finish up, so I'll just say in relation to that, what I've been doing in order to overcome some of these challenges to justice in a broader sense. In many cases, in many contexts, individual reparations is very difficult to come up with a list of the victims, to be able to provide individual assistance to them. So I've been working more on trying to formulate how some sort of collective or community reparations can be provided. For example, a school building in a conflict-affected communities, free school fees, free medical for 3 or 4 children of a victim, something easy to achieve, because reparations, in my view, often becomes overcome by the administrative difficulties and, of course, symbolic reparations. So that's my time up. Just in summing up, I've been asked to talk about the challenges of justice in relation to in relation to genocide. And I want to just share with you that you can use this transitional justice framework to analyze and remember some of those challenges, the challenges of seeking the truth, the denial, the lack of capacity to seek it, the large number of cases, the inability of victims to put forward their case, in relation to prosecution, the lack of political will, in relation to reparations, the weakness of the victims, the failure of funding, and the complexities. And the fourth quadrant of the transitional justice framework, that of reform. There are many challenges, and I'll leave that to you because you are the experts in the reform of the Bangladesh context. Thank you very much for the opportunity to talk to you, and I look forward to hearing some questions.
Great. Thank you, Patrick, for your presentation, and both to Professor Massimino and Patrick for their comments. I do want to take, we have about 15 minutes or so left for questions. So I was hoping we can just jump right into it. You can feel free to type your questions in the chat. If you have a question, another option is to use the reaction option of indicating that you want to raise your hand. And I'll try to keep an eye on whether anyone is doing that. It's a little bit challenging with so many participants. I'm very excited to see how many people have joined us today. Another option is, I think, as no one's yet speaking out, if you do want to just unmute yourself and begin. If we end up with people speaking over, then we can shift back to using the raise their hand options. So any questions? If not, I can jump in. I, of course, have many because I find these topics really interesting, and I think there's so much we can learn from our speakers. Let me see. I think there's one new message coming through. Okay, well, I'll go ahead and jump in then. I think you did reference the Rohingya universal jurisdiction case in Argentina. Touched a bit on it, and also noted that the pandemic is causing some challenges with that. And I was wondering if you could go into a bit more detail and maybe also help provide for the students the kind of the quick overview of what that process was and where we're at and what you anticipate in the coming weeks, months, years.
Okay, thank you, Nicole. Sorry, I had a problem unmuting. Yes, of course, universal jurisdiction is not a panacea, we say in Spanish. It's not the one option that is great. There are many challenges that to be pointed, besides the great ones presented by Patrick, that I fully agree. Actually, sometimes I think that when one is a national, it's very difficult also to study one's own country, because one already has a historical sort of, it's embodied in the DNA to have certain political views, etc. So that can bring some bias to studying the national problems. So that's another challenge that we would have to think about, and I could speak about Argentina in that case in particular. But anyway, regarding universal jurisdiction, Argentina, like I said, has the possibility in its own constitution since 1853. It's a very old law, actually, or norm. And it has opened up recently in the 20th century only. It's of use in the 20th century mainly, probably as a consequence of the opening of universal jurisdiction in Europe during the 90s due to the crimes committed during the dictatorships in the 1970s. Therefore, the Rohingya presented through an NGO, a non-governmental organization based in the UK, presented the case in Argentina. I think the presentation is translated into English. I can make it available for everyone. I actually have it, but I think it's available everywhere. I'm not sure, but anyway, I can circulate it, where it was presented for the cases of genocide and crimes against humanity. And mainly the evidence was based on the report by the UN of the special mission to Myanmar that the UN came out with a very good, extensive report. The presentation is very complete. It was, I think, presented November last year in Argentina. It took a while to be received, to open up. It's very procedural. It's in the process of, Argentina has a federal system. It's quite a big country, territorially speaking. I don't know if you're aware of the US organization, but it's very similar to the organization in jurisdictions of the United States of America. So we have a provincial system. Each province, which is similar to a state, has a jurisdiction for specific crimes. We're talking about the criminal system. And then we have a federal jurisdiction, which deals with other crimes. One of the federal jurisdiction opens for what we know as international crimes. So when we have a case of genocide, for example, through universal jurisdiction, it would open up in the federal system. In the ordinary tribunal, there's no specific tribunal. This opens in the ordinary judiciary. And so with the cases of the crimes committed in Argentina during the 1970s, those are in the ordinary judiciary in the federal system. And we have many challenges, of course, many. And so it opened up in the federal system because it's for genocide and crimes against humanity. And in the instance that we call the investigative instance, right? So now they have been called to, it's very difficult to talk procedure in English, I'm sorry. But they have been requested, the claimant has been requested to formally confirm the claim. So that's what always happens when one goes to present a claim, then one has to confirm the claim. One can say, okay, that's no interest to continue with the claim. Of course, it depends if it's a public crime or it's a crime of private instance, etc. But in this particular case, there's no prosecutor, right? It's an NGO represented by a lawyer presenting it. That's a specific figure called the claimant. Then it would be taken by the prosecutor. So unfortunately, like I said, the pandemic has stopped this. I know that several papers have been sent around, but I don't have much further information. Actually, I've been trying to talk personally to the it's not a tribunal, it's a judge, but not the judge actually, it's the office, to know the advances that have happening. It's a very slow process, not only because of the nature of the crime, but also because of the territorial distance and the difficulties of dealing with it in international crime, but also because of the justice system of Argentina. It happens to be very slow, and it has become a lot slower during the pandemic. So hopefully, I mean, I know the universal jurisdiction for the crimes committed during the Franco's dictatorship in Spain has opened up and has been received positively, and it's under investigation. but I am not sure that is the case with the Rohingya. I don't know. I could give my personal opinion, but I actually don't have one. It's a very complex scenario because I don't think they would apply the foreign non-convenience doctrine, which is that this forum is not the convenient one for the case because we've received and we've opened universal jurisdiction before. And although there is a case in the ICJ, is different. It's not a criminal case. It's the states there. It's not. Maybe if the ICC opens a case on certain grounds, of course, then we will say the ICC is the one, is the jurisdiction that will deal properly with this particular case. I am not sure. Of course, this presents a lot of challenges because victims will never be able, or at least maybe 2 or 3, I don't know, sponsor victims will be able to come to court. Perpetrators would only be tried and would only sit if they come to Argentine territory. But I think it's very symbolic, right? It means that there is international interest and there is pressure. And I think when I said before that I think a lot of people are aware of what happens, I have an experience, particularly on Iraq, that I would like, if I have a couple of minutes, sorry, Nicole, I'm like taking over the everything. I don't know if I have 2 minutes, but
just maybe 1 or 2 minutes to touch on it. And well, yeah.
Okay. When I said that people seem more aware, actually, I don't know how aware they were in the 80s. I was born in the 80s, so I don't know how aware they were of the laws and everything. But what I've noticed is in particular, when I went to Iraq, is probably the place where right after crimes were committed or while crimes were committed, I was there. If not everything that I've studied is afterwards, many years after the crime was committed. And I realized how much knowledge people have of the law, of the possibilities of judging, of trying, etc., of truth commissions, of establishing alternative forms of justice as well, of reparation, etc. And I think that's what, I don't know, might have a positive impact in the future, in the sense that, for example, universal jurisdictions will be opening up as they open up in Germany, in Belgium, etc. So maybe there is a little bit more will, in a positive sense, to think that justice, in a formal way, of course, I'm talking, will come in the future. So I do hope to have more update on the Rohingya case, and I do hope it will open up. Who knows where it will end? Because like I said, there are many, many things, unfortunately, because we're thousands of kilometers away of the actual place of the crimes. So it's complex. Yeah, sorry, that's it, Nicole. But
Thank you very much. Oh, I'm so concerned.
Oh, I think maybe I have bad signal.
Okay. Connection, yeah. We have, I think, only 8 minutes left, but we do have a question from a participant. So I think best, oh, I'm not sure if my connection's poor, for us to turn to that. So if the individual who, we now have 2, you can hear me? Okay. So we have 2 questions. If the first person, Mohammed Mamoun, would be willing to unmute and ask your question, I think it would be best if you present it. I think we may only have time for that question, and then just a minute of reflection from each of our speakers before we have to end.
Thank you very much for giving me the floor to ask the question. My question to the speakers that do the speakers think the access to justice to combat genocidal actions same for the countries of this part of the world, like the region of Asia and European countries, as well as the countries of other part of the world, or there are some other factors which intervene in ensuring justice for genocidal actions and genocide happens in different countries? Is there any difference or any other factors which intervenes in justice?
Yeah, I think that's a very interesting question. And I think actually there are significant differences. And if we look at, one might tend to want to say, oh, these are difficult issues all over the world and it's always the same. But if we look at some of the indicators of what's been done, we'll find that it's not the same. if you look at the membership of the International Criminal Court, you will find that Asian countries, that Asia, the region of Asia, falls far behind the membership, the number of countries which have joined the International Criminal Court. If you look at the proceedings for prosecutions and the national courts, also Asia falls behind on most measures. And we might ask the question why this is. I think there are a number of factors, to be honest. I think that there is in Asia, we have a lack of a cohesive or unifying factors that are present in other countries, notwithstanding that the countries are very different. For example, in Latin America, they have the unifying aspects of colonial powers and the languages of Spanish and Portuguese across the continent. In Africa, you see the same with English and French. In the Middle East with Arabic. In Europe with English, United States English. And then you come where we work in Southeast Asia, for example, you have Khmer, Burmese, Indonesian, Tetum, all those different languages. There's no unifying aspect of it. And you see a very strong determination for national sovereignty and not to release any aspects of the national powers reflected in, for example, the ASEAN Charter and the powers of the only human rights body in ASEAN, AJAR. So I think that it is more difficult. I think this issue around Asian values and a very strong rejection of interference from the West and the North in Asia. And I think when we look at it on the face, it is significantly different and more difficult in achieving justice in many ways. But I think the rest of the world is also not aware of how much progress has been made in the last 20 years in Asia. Truth commissions, now the sub-national truth commission created by the parliament in Aceh, I think probably the first permanent body established to implement a truth commission's recommendations in Timor-Leste. Following that truth commission, the binational truth commission between Indonesia and Timor, the truth commission in Thailand, in Nepal, the courts in Bangladesh, the court in Cambodia, the national trials in Jakarta. I think the rest of the world's not really aware, and I've heard international lawyers say nothing has happened in terms of transitional justice in Asia, which is far from the truth. And I think perhaps most impressive is some of the civil society work in that context where governments are so resistant. Civil society work in coming up with creative solutions for truth-seeking and reparations to help victims at a very grassroots level is very impressive in Asia. So I think it is more difficult in many ways for a number of reasons. And it's also far away from the northern centers. It's a totally different time zones. We have less interaction as well as the language and all those other issues. More difficult, but there's a lot happening in terms of transitional justice now. The ICC cases in terms of the Bangladesh-Myanmar context, the Philippines, things are moving quite a lot in Asia, despite the difficulties.
Great. Thank you. And we are almost out of time, so I just want to give our speakers an opportunity to just have a moment of kind of concluding thoughts. But also in the context of that, we do have one other question, which I think is formulated as a yes or no question. So I think you can give your yes or no and not necessarily further develop it, but at least so that this person's kind of interest is satiated in some way. The question is forcing a group of people to give up their cultural heritage akin to genocide? So if you could provide just a very quick response to that, and then also if there's any final thought you'd like to share, and if I can ask you to do it in 1 to 2 minutes, that would be great. So, Professor Massimino, would you like to begin?
Yes, sure, Nicole. Yes, I think yes. And that's going back to Lenkin's original definition of genocide. The idea was that cultural genocide, of course, and the destruction of a culture is the destruction of an identity. So I certainly agree. Also, I would like to just finish by saying, well, thank you to everyone for this wonderful conference and giving me the opportunity to speak. and to hearing the panelists as well. It was wonderful to share with all of you, and I hope we had more time to discuss a bit more and the challenges of each of the particular institutions that we may use, and the positive aspects, of course, as well. But I hope it was useful, and to meet you soon, and hopefully be at the closing ceremony of the conference. Thank you.
Thank you. And Patrick?
Thank you. This is a quite a large question, but I agree. Yes, in terms of the intention of genocide as drafted by Lemkin, and yes, that's true. But I think it's important that people realize that legally, at the current time, cultural genocide is not is going to be extremely problematic if you try to include that in a criminal prosecution for genocide. It's very difficult because in many of the communities I work with, for example, in Papua and Indonesia, they feel like genocide is being committed against them, many of them right now. They're destroying their culture, their peoples, and yet there are scholarly articles being written saying it's not genocide legally. So, this is a bigger issue as to whether that is part of the term genocide and whether it's included in the legal definition of genocide. Too long a discussion for today, but a very interesting one for the future. I just want to say thank you very much for the opportunity to talk to you all today. And I just want to remind you that all of the things that were referred to today about what happened in Latin America, what's happened in Asia, what's happened in other places, the establishment of the International Criminal Court, all of these issues didn't come about by themselves. When we talk about the difficulties, and some that I presented about prosecuting, seeking the truth, helping victims, they are major difficulties, but we are moving in the right direction. We are making progress, and it's only by people like you becoming involved, dedicating part of your work, part of your studies to these type of issues, connecting with other people, that these changes take place. So I encourage you to keep going in that direction. It's a wonderful thing to be part of this amazing international community that is fighting for human rights and justice. So thank you very much for your opportunity today.
Wonderful. Thank you very much to our panelists. This was an excellent discussion. We are a minute over, but I feel like we covered a lot of ground. I'm very impressed with what we were able to discuss and the nuanced points that were made. So thank you very much. And Nasrin, I'll turn it over.
Yeah, thank you, Nicole. Thank you so much. I was amazingly watching how you are moderating. So it was very interactive, and discussion of Patrick and Irene, I thought it also enriched me. Whenever I listen to Patrick, every time I learn something new. Thank you, Patrick. And Irene, this is for the first time I'm meeting you. And I was amazed with your discussion. Thank you so much. It was very, very resourceful. It was not a random discussion. It was very, very much close to academic and practice also. So who are interested in this field to learn and to research, this webinar will be an asset for them. I'm very much grateful to the moderator, to the panelists of the webinar. Patrick, Irene, and Ridwan sir was there. He also put up very good input. I'm just now inviting you all at the closing ceremony of the second International Law Fest, which will be held on 19 Standard Time. In Bangladeshi time, it's 7 p.m. and in Standard Time, it is 19. So we are inviting 3 of you in the closing ceremony. Today, in Bangladesh time, it is on today. I think it is different for Irene in the USA. So Irene, you're invited. Please have a sleep and join to us in the morning. Patrick and Nicole, please join to us in the closing ceremony. We will have a very good get together with all academicians and practitioners who are working for the international humanitarian law in a big aspect. So welcome to the fest, and I think Nicole will declare the closing of the session. Thank you so much.
Thank you everyone for joining us today, and I look forward to seeing you this evening. Take care.
And thank you, Nicole, for your great assistance through this.
My pleasure.
Thank you, Nicole. Thank you, Patrick. Thank you, Ren.
Thank you. Thank you. And great